Welcome to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Karlan, along with Joe Bankman.
Pam, the big news in law and even outside of law right now is the retirement of Supreme Court Justice Kennedy. And today we're going to have a special podcast looking at what this means for the court and for the rest of us.
Well, that's right, we are. And today our guest is Jeff Fisher, the co-director of the Stanford Supreme Court Litigation Clinic and a professor of law at Stanford. He's argued 36 cases at the court, including several path-breaking cases that probably have affected some of our readers directly every day, and lots of them, listeners every day, but lots of them because they're cases that people have noticed. And one of them is Riley against California, the case where the Supreme Court recognized that cell phones are fundamentally different from pretty much everything else, and therefore, even when you're arrested, the police need a warrant to search your cell phone. But two of his probably leading cases bear directly on our topic today because they were cases that the Supreme Court decided by narrow margins in which Justice Kennedy wrote the opinion for the court. The first of these is the aptly named Kennedy against Louisiana, where the court held that the death penalty can't be applied to individual defendants who do not kill. That was a case about whether a state could execute people for child rape. And the other is just a year ago, Pena-Rodriguez against Colorado, in which the Supreme Court said that courts can look behind jury verdicts when there are allegations of serious racial bias in the jury room.
Right, and our other authority today, Pam, is you, because you're co-director of our Supreme Court Litigation Clinic, and you've now argued 8 cases before the Supreme Court, which is an amazing record as compared to almost anyone in the country except Jeff. And I want to note that each of you have argued and won a case in the recent months. And Pam, you won the Lozman case, which is a First Amendment case about someone's right to annoy a city council.
Yes. And I should say that we have lost some cases recently as well. We had 3-5-4 losses this year at the Supreme Court.
Well, 5-4 losses is going to get us into our main topic. But before that, Jeff, I want to congratulate you on winning a case called Carpenter, which is a Fourth Amendment case about whether the police can effectively trail you through your cell phone usage.
Right. Well, let me make one minor correction first, which is I did not present oral argument in Carpenter. I was co-author of the briefs with some lawyers at the ACLU, and one of their lawyers, Nate Wessler, argued and did a terrific job. But this was a 5-4 decision written by, I guess to precede our conversation later, our new swing justice, Chief Justice Roberts, where the court held that the police have to get a warrant before procuring the locational information that our cell phone companies all gather on us on a daily basis, indeed a minute-by-minute basis, to paint a portrait of everywhere we've been over all the times we've carried our cell phone with us.
Well, congratulations on that, and condolences on the 5-4 cases you two have lost. And let's talk about 5-4 cases in Kennedy as a swing justice. What does that mean?
Well, what it's meant in recent years, especially since the retirement of Justice O'Connor, is that there were a lot of cases that went up to the court, often ideologically charged cases, where Justice Kennedy found himself between two different wings of the court, the more liberal wing of Democratic appointees and the more conservative wing of the remainder of the Republican appointees. More often than not, Justice Kennedy sided with the Republicans, but on occasion he would swing the other way, so to speak, and join the liberals. So a lot of cases were kind of all about what would Justice Kennedy think about it and trying to make arguments to Justice Kennedy. And so we have a big change on the horizon where that's not going to be the name of the game anymore.
And one of the things I think that's interesting about Justice Kennedy is a generational change. He's of a different generation than the other Republican appointees to the court, and therefore he came up in a different kind of Republican Party. It was a Republican Party that was a little more libertarian, a little more socially liberal. It wasn't quite the kind of conservative legal movement that I think the more recent Republican nominees to the court have been part of.
And it wasn't, as I understand it, that Justice Kennedy was just a swing vote. It's that arguments, as Jeff says, were directed to him, and the opinions, many of which he would write, also would reflect his jurisprudence.
Right, and that jurisprudence, more than anything, I think, is notable for the difference Pam was just describing as compared to other recent conservative appointees who've taken a much more rigid, formalist view of the Constitution and tied it more directly to the original understanding as best could be gleaned or other highly formalistic rules. Justice Kennedy was much more, at least in my view, about fundamental fairness, and he would look to see what really offended him or outraged him, and then he would kind of work backwards from that sometimes in a way that the other conservatives don't necessarily do.
And I think the other thing that's kind of interesting about Justice Kennedy and worth remembering is he wasn't the first choice for his seat even when he was nominated. The first choice for his seat, and it's something that I think people have kind of forgotten, was Robert Bork. And you can imagine that the last 20-something years, 30 years on the court would have been very different if Robert Bork had held that seat than if Anthony Kennedy held that seat. And he was the third choice for that seat.
What will he be remembered for? Can you paint a picture for us about the areas in which he's really kind of tread new ground?
Well, I think the beginning of any conversation in that regard has to start with gay rights. They're the most prominent decisions, at least in the public eye, I think, where Justice Kennedy provided the critical vote to constitutionalize the right of same-sex couples to marry, and before that to prohibit states and localities from discriminating against gay people. So that'll be at the top of the banner for him. Probably the other highest profile case he'll be remembered for is his opinion, again, tilting the balance of the court in Citizens United, allowing unrestricted campaign finance donations to go in. So those are probably the two biggest areas. We could talk more about some of the more next level down areas. But I think I'd love Pam to make one comment before we talk too much about his jurisprudence, because Pam made a great comment when we were chatting the other day about his legacy might be remembered as much for the moment in which he retired and what happens afterwards as anything that he actually did on the court. And I thought that was a neat point.
Yeah, and I think we'll turn to that a bit more later as well. But I wanted to focus on one more area where I think Justice Kennedy has been pivotal over the last 25, 30 years, and that's abortion rights. At the time that he was nominated for the Supreme Court, people thought that Roe against Wade was in peril, and that a change in the overall balance of the Supreme Court would lead the Supreme Court to overturn Roe against Wade and hold that women don't have a fundamental constitutional right to decide whether or not to terminate a pregnancy. And he was part of a 3-justice block, along with 2 other Republican presidential nominated justices, Justice Souter and Justice O'Connor, in the Planned Parenthood against Casey case in 1993, where the Supreme Court reaffirmed parts of Roe against Wade, but also cut back a little bit on the extent of the protection. But then you fast forward to the most recent abortion cases on the Supreme Court, and in the Gonzalez against Carhart case, Justice Kennedy retreated somewhat from a really aggressive protection of abortion rights. And so there's this kind of interesting question where that's going to go next.
Well, Pam, if I could just add one thing
Sure.
that makes it even more salient the moment we're in right now, is that after he took a step back in Carhart, he took another step, you might say, back forward, at least to some degree, just a couple of years ago in Whole Woman's Health, where he said that when a state passes a law restricting a woman's right to abortion, ostensibly for health reasons, but when those health arguments don't actually pan out on the ground, that law has to go by the wayside. And that was a 5th vote in that case. So it'll be right away. Other state laws like that are in the courts and likely to be up at the Supreme Court very soon.
This is Stanford Legal, and today we're talking about Justice Kennedy and the Supreme Court and where we go from here with Jeff Fisher.
I want to come back to Kennedy's decisions on gay rights in a second, but let's finish off with abortion. Kavanaugh's been appropriately cautious about how he'll rule, but if he rules in the same way more recent Republicans have ruled, does this mean the end of Roe v. Wade? I think that's what most people are wondering the most.
Well, I'd be very surprised if we're going to see a headline in the paper or a sentence in a Supreme Court opinion that says we overrule Roe versus Wade. But at the same time, I think it's quite likely that what we'll see are cases like Holman's Health and other cases involving state laws that are very restrictive and often for very tenuous reasons being upheld one after the other. So Roe may not be overturned in name, but in substance, I think it's at great peril.
And I think one thing that it's useful for our listeners to understand is there are two kinds of abortion cases that might go up to the Supreme Court in the near future. And I think Jeff is 100% right that in the cases that simply impose additional restrictions, so there are a lot of them that are what are referred to as trap or targeted regulation of abortion provider cases, where they require all sorts of onerous requirements on clinics that force clinics to close. I think Jeff is absolutely right. In those cases, the court can uphold those without ever coming right out and saying we're overturning Roe against Wade, because all they have to say is, well, those particular restrictions aren't themselves what the court has called an undue burden on the right to abortion. But I think there are some state legislatures out there that may start to just absolutely prohibit all abortion from the time that a pregnancy can be detected. I mean, all you need is one state to do that, and then the Supreme Court has to take, if it takes that case, has to decide, is Roe going to be overturned or not? And so down the road, we may see the Supreme Court being forced to confront that question directly.
Well, I mean, that's kind of the interesting question, whether it will be forced, because lower courts would at least, you would think, be bound by Roe v. Wade to strike down those laws. So then it will be up to the court whether it will exercise its discretion to hear one of those cases and take that big step. And that'll be one of the first big tests for perhaps Chief Justice John Roberts overseeing this new group of justices.
Yeah, and one of the things that we've already seen is that as Jeff says, lower courts decide the vast majority of these cases. And one of the questions is who's being put on the lower courts, because you just had a case recently in which a recent appointee to the Fifth Circuit, which is the circuit that oversees cases from from Texas, from Mississippi, and from Louisiana, all of them states that have passed a lot of abortion restrictions. The judge referred to the moral tragedy of abortion in his decision. So you can imagine some lower courts trying to get out ahead on their skis of the Supreme Court and upholding one of these laws.
I mean, one other thing I'll add, which actually ties us back to Justice Kennedy in another area of law again, but every once in a while, a lower court will just step out there and basically force the Supreme Court's hand. The Supreme Court of Missouri did this years ago, involving whether juveniles could be punished by the death penalty. And the court took the case and excoriated the Missouri Supreme Court for reaching out to do something that really involved overturning prior U.S. Supreme Court precedent. Nonetheless, Justice Kennedy provided the fifth vote there to ban the execution of juveniles. And this is another area of jurisprudence that's going to be potentially wiped away, or at least limited after his retirement, which is limitations on the death penalty and extreme punishment of juveniles.
Final question on abortion. It's one our listeners are going to want me to press you on. Lower court oversteps its bounds, rules Roe invalid. Now the Supreme Court has to deal with it. Post-Kennedy era, what do you think they'd say?
So if there's a state law that actually forces the issue,
Yeah.
with the, assuming we have a Justice Kavanaugh and the same membership, I think I really do not know. I mean, I think it really probably comes down to Chief Justice Roberts as to how he views the court's legitimacy and public standing, and I think that's something that has entered probably his mind in the healthcare cases and other big ticket item cases, where I think he, partly because he's the Chief Justice and partly because his view of the institution, he has at least occasionally been willing to perhaps hold his nose and uphold something that he thinks is better for the court in the long run. That, to me, would be the question. But I would not pretend to be able to get inside his head or and say how he'd decide it.
I mean, you raise a great point there, Jeff, about the Chief Justice thinking about the institutional kind of institutional position of the court and the court's reputation in the citizenry as a whole as not being an intensely political entity. And that takes us to an area of law that the Supreme Court looked like it was going to decide something about this year and didn't. And that's the question of the constitutionality of political gerrymandering. Because one of the things that happened is over the last decade, Justice Kennedy has been viewed as somebody who would like to deal with political gerrymandering but hadn't yet seen how a court could do it. And this year, when the Supreme Court had these two big political gerrymandering cases in front of it, the Chief Justice stepped in at the oral argument and said, maybe we shouldn't be deciding political gerrymandering cases at all because it will look like we're either supporting the Democratic Party or the Republican Party. And so there are some areas of law where there's kind of unfinished business. And the question is that unfinished business going to be something a post-Kennedy court takes up, or do you think there are areas of law that are now kind of frozen in place?
I'd say a little bit of both. But I think that the decisions, the gerrymandering cases, I think highlight just what we were talking about, which is that there's going to be occasional cases where the chief, especially acutely aware now of the political appointment division in the court and the increasing perception that the court is a political and politicized institution, that he's going to try to step back from the brink. On the other hand, there are other projects, the Chief Justice and the other conservatives, I would think, are going to go full speed ahead. I mean, they already did this in the Voting Rights Act, gutting a big provision of the Voting Rights Act, as you could say better than I could. So things like affirmative action and some other project areas, I don't think the court is going to hold back.
And if the court doesn't hold back on affirmative action, and when we say doesn't hold back, we're thinking ruling variants of affirmative action unconstitutional. It's really consistent, I would think, with holding back on gerrymandering. If you take a cynical, it's all Democrats versus Republicans, because right now it's the Democrats that want the court to step in. So not stepping in is consistent with a Republican position. Cutting back on affirmative action, the same thing is true. So to the cynic, what you're saying would be all consistent with a holding back, not holding back, in a way just being kind of code for we're going to do what people think we're doing. We're appointed by one party. We're going to act in accordance with that party's agenda.
I don't have a big disagreement. Pam may have something to add. I mean, obviously, political gerrymandering is not strictly speaking a Republican enterprise. There are Democrat gerrymanders in various pockets across the country, although writ large, I think the statistics show that gerrymandering favors Republicans more right now.
Currently,
because they have the power. If the Democrats had the power, presumably we might be in a different position.
Right.
Well, and one of the things is, and I wonder, Jeff, what your reaction to this was the very last opinion from Justice Kennedy on the Supreme Court was a 2-page sort of why can't we all get along opinion in the travel ban case. And he seems to be decrying the increased polarization and incivility of American politics at the very moment that he steps down. And this takes us back to what you were talking about earlier. The very moment he steps down and gives the opportunity to nominate a successor to probably the most polarizing figure in national politics in American history.
But he's pretty old. I mean, I don't know. We don't mention ages generally, but this isn't someone who is a mere 70. So for him to stay on, I mean, if we look at the ages of the justices, isn't this a kind of a big problem for many of them? That is, they might want to retire, but they might not want to retire now, but staying on is really pushing them up in age.
Well, we'll be back with more from our guest, Jeff Fisher, talking about the future of this venerable institution and its very venerable members next on Stanford Legal on Sirius XM Insight 121.